Hello viewers, how are you all doing today? Welcome back to another session of Economics and Law 1. I am Dr. Ankit Shrivastava, Assistant Professor of Law at RGNUL Punjab. The topic of our discussion today is the economic theory of the law of torts. The legal system deals with an enormous variety of legal disputes that traverse a wide variety of subject matter, such as economic interests, material possessions, criminal offences, etc. Within this framework, the law of torts occupies a central position, addressing a wide range of civil wrongs committed by one party against another. The law of torts deal with actions that cause harm to an individual, such as negligence, defamation, product liability, rash driving, and many more. When a tort occurs, the aggrieved party, that is the plaintiff, can bring a lawsuit against the wrongdoer, that is the defendant, seeking compensation for their losses. It is primarily concerned with compensating the victim and creating deterrence for dangerous behavior. The law of torts performs the important function of assigning liability for behavior that is considered socially unacceptable. It provides for a set of rules that establish acceptable conduct in society and the consequences of failing to meet those standards. It discourages risky behavior by holding the wrongdoers accountable and acts as a deterrent, encouraging individuals to take reasonable precautions to avoid causing any harm to themselves and others. The economic theory of the law of torts provides a different perspective on the role of the law of torts in shaping societal behavior. It views the law of torts as a tool that promotes economic efficiency, or in other words, it analyzes the law of torts through the lens of economic efficiency. It aims to study that how the law of torts can be used to incentivize optimal levels of safety and accident prevention. Efficiency in this context refers to maximizing social welfare by minimizing costs such as accidental costs like medical bills, lost wages, and damage to property, and precautionary costs, that is, investment in safety measures. The economic theory aims to use the law of torts as a tool to change or influence the decisions of both the wrongdoer, that is, those who might cause harm, and the victims, that is, to ensure a reasonable level of precaution in order to ensure economic efficiency, and even if deterrence fails, it aims to assign appropriate liability in order to internalize the costs caused by the externalities. This notion of externalities is a key concept in this theory. Externalities are said to occur when the actions of one party lead to consequences that impose costs on another party. For example, if person A crashes into the parked car of person B, it can be said that person B would suffer unnecessary costs on account of person A's negligent actions. In this example, we can see that the accident creates externalities. Person A will incur costs associated with repairing his own car, but person B will also bear some costs. Economic theory talks about internalizing these externalities. Internalization occurs when the injurer is held liable for the full costs of the consequences associated with their actions, that is, paying for the cost incurred by the victim as well. This is achieved by awarding compensation to the victim for his costs. The imposition of liability creates a deterrent for engaging in risky or negligent behavior. Furthermore, it also encourages people to take responsible precautions, failing which they may be held liable for contributory negligence. We aim to understand the economic theory of the law of torts in detail and examine how the theory influences various legal aspects such as duty of care, standard of care, and associated liabilities. We will also understand the critique of the theory, ultimately gaining a comprehensive understanding of the economic theory of the law of torts. So let's discuss the efficiency paradigm. As we now understand, the economic theory of torts rests on the fundamental principle of economic efficiency, which is associated with the maximization of social welfare by minimizing the total costs resulting from legally inappropriate behavior. These costs can be categorized into two main groups. The first one is accidental costs: medical bills, rehabilitation, lost wages, property damage, intangible pain and suffering, etc. And the second is precaution costs. These are the costs incurred in order to prevent accidents from happening in the first place. For example, safety measures in buildings, training programs for employees, and insurance to mitigate potential losses. Herein, the law of torts can help achieve efficiency by influencing the behavior of society at large and preventing the aforementioned costs. The key factor for achieving the said efficiency is to utilize the inherent mechanism of the law of torts, which is the assignment of liability. The law of torts imposes financial liability on the wrongdoer for the harm they cause and the resultant liability, creating a financial disincentive for engaging in wrongful conduct. When the potential wrongdoer knows that they will face financial consequences and will be responsible for the full extent of the harm they cause, they are more likely to take reasonable precautions to avoid such behavior in the first place. For example, the economic theory argues that when a factory owner knows that he can be held liable for the injuries caused by any unsafe machinery or failure to take any precautions, that is, safety precautions or lack of appropriate training, then they will be more likely to invest in safety mechanisms and take due care to avoid any potential lawsuits and associated costs. Another key concept of the law of torts is a reasonable standard of care. Economic theory plays an important role in shaping the reasonable standard of care. This standard is the bedrock of cases of negligence under the law of torts, one of the most common types of tort claims. It requires an individual to act with a level of care that a reasonable person would exercise in the same situation. For instance, while driving on a busy road, a reasonable person would drive at an appropriate speed in order to prevent any accidents. But if a person ignores the same or fails to exercise this reasonable standard of care, they can be held liable for negligence. Now, from the perspective of the victim, we can see that if a person has the assurance that they will be fully compensated for their injuries, they may be less likely to take steps to minimize their own losses. The economic theory addresses this by focusing on the allocation of accident costs, which has the potential to influence the behavior of the victim. The law of torts addresses this issue through the use of doctrines like contributory negligence, wherein the victim's fault is considered a contributing factor and the liability is decided accordingly, and comparative fault, which compares the degree of negligence of the parties and is usually used as a defense to reduce the amount of compensation. Now, these doctrines are usually used as defenses by the plaintiff and have the effect of reducing or completely eliminating the victim's compensation if they are found to have contributed to their own injuries. This creates a deterrent on the part of the victims to take a reasonable standard of care in order to avoid injuries. For example, if a jogger is jogging on the road at night without any reflective gear and is hit by a vehicle, the victim may be said to have contributed to his own injuries on account of his failure to take reasonable precautions. We can see that the economic theory of the law of torts uses the inherent mechanism of financial liability in order to create a deterrence factor on the side of the wrongdoer, and it also utilizes doctrines of contributory negligence and comparative fault in order to ensure that the individual also has a degree of responsibility for their safety. Now let's talk about the applications of economic theory. The economic theory is not singular in nature. It offers a framework for analyzing various aspects of tort law, helping us understand the impact and utility of various legal concepts under the law of torts. Let us take a closer look at some of these key applications of this theory. The first being duty of care. The duty of care is a fundamental concept of tort law. It is a legal obligation for an individual to adhere to a reasonable standard of care to avoid any acts that have the potential to harm others. Economic theory can help us understand how courts might determine the existence of a duty of care. For instance, if a hiker is walking on a public trail, a nearby property owner has a large open pit on their land bordering the trail. The economic theory suggests a duty of care might exist if the benefits of the landowner taking precautions, that is, fencing the pit or placing appropriate signs, outweigh the costs, that is, fencing material or labor. Here, the potential for serious injury to the hikers justifies the imposition of a duty on the landowner to exercise a reasonable standard of care. Another instance might be that the municipal corporation is engaged in cleaning the drains during monsoon season and has left a drain cover open on the public road. Now, it is evident that the municipal corporation has to exercise a reasonable standard of care in placing appropriate barricades in order to prevent any accidents, because the accident will lead to unnecessary costs, that is, medical bills and compensation for vehicle damage. Lastly, consider the instance of a factory owner again. The prevention cost of ensuring safety mechanisms for workers is a reasonable standard of care, as it will prevent accidents. The second is the rule of strict liability. Strict liability is a legal doctrine that holds a person responsible for the harm caused by their dangerous activities regardless of the negligence factor. The economic theory can be utilized in situations where the benefits of engaging in activity are high, but the potential for accidents and associated costs are also high. For example, economic theory might support strict liability for companies transporting hazardous materials. The potential consequences of an accident involving hazardous materials are so severe that even the most careful precautions might not be enough. Strict liability incentivizes companies to invest heavily in safety measures and minimize the risk of such accidents altogether. Similarly, a manufacturing plant that uses hazardous materials in production may still be held liable even if it has taken reasonable precautions. In such a situation, the advantage this rule offers in terms of efficiency is the reduction of administrative costs. The courts no longer need to determine whether the defendant has taken due precautions. It also reduces litigation costs for the parties. The rule of strict liability also forwards the insurance function, whereby the individual or business engaging in such risky activities will take appropriate insurance cover in order to cover any costs resulting from such liability. Herein, economic efficiency is achieved by adequately compensating the victim, ensuring the maximum level of care is taken, and potentially ensuring the unforeseen costs are already covered by appropriate insurance, thereby reducing administrative and litigation costs. Now let's talk about the criticism of the economic theory. The economic theory offers us a perspective or justification of how the inherent component of financial liability under the law of torts can help the law fulfill its purpose and also provide a rationale for the imposition of liability in order to internalize the costs of wrongful behavior or essentially right the wrongs. But this theory also has some shortcomings. A critical critique of economic theory is targeted at its underlying assumption that the people are purely rational actors who always make decisions to maximize their economic gains. Critics argue that human behavior is far more complex. Factors like emotions, moral principles, and risk aversion can significantly influence decisions, especially regarding safety precautions. For example, the theory might predict that a parent would use a car seat for their child to minimize the risk of injury during an accident. However, real-world behavior may be influenced by factors such as inconvenience or lack of care during a short trip. Another example might be that a person may drive fast on a congested road during an emergency, even though such behavior is risky and the associated prevention costs may be lower. The decision to undertake such a risk might be based on emotional factors. The economic theory we have seen prioritizes efficiency, aiming to minimize the costs associated with wrongful conduct. But in doing so, it can overlook distributional concerns, meaning the fair share of the allocation of costs and burdens within society. For example, a wealthy corporation may have the ability to absorb the costs of a few product liability lawsuits without any significant problems. However, this outcome may be unfair towards the victim and the consumers who suffered serious injuries due to the defective product. Hence, it is argued that while dealing with efficiency concerns, the element of fairness should be given due consideration as it is an important component of the legal system. Economic theory tends to ignore the concept of fairness and justice as it has a myopic view of allocating costs to achieve efficiency. Another situation may occur due to asymmetric information. The theory assumes that both parties have full knowledge of the risks involved, but it might not be possible in reality, as there is a possibility of unforeseen circumstances wherein it might not be possible to affix liability to anybody. Furthermore, economic theory is focused on quantifying the costs associated with a person's behavior. However, it is not possible to ignore non-economic damages like the pain and the suffering of the victim or the family members. Furthermore, it is not possible in every situation to accurately assess the damages and award adequate compensation, leaving the victim at a disadvantage. For example, a person who suffers a car accident or a worker who suffers an accident in the factory might receive financial compensation, but it is possible that the said compensation fully captures the ongoing impact of the injuries. Lastly, the economic theory raises ethical concerns as it is lopsided towards the wealthy who may have the resources to easily absorb the costs, thereby being disadvantageous towards the less fortunate victims who will suffer disproportionately from the wrongful act. This is also particularly true in the legal context, as wealthy individuals will have access to better legal services to represent their interests adequately before the courts, whereas the victims might lack the same. Another aspect of the same may be situations wherein the wealthy individual or corporation refuses to undertake preventive costs on account of their ability to pay for any compensation or lawsuit that might arise, again leaving the victim at a disadvantage as the situation might have been avoided. Therefore, we can say that the economic theory does a commendable job at offering justification for the imposition of financial liability as a social tool for altering behavior, but it ignores a lot of key considerations that are the cornerstones of the legal system, such as justice and fairness. Now let's talk about the game of probability and beyond pure economic efficiency. As we have discussed, economic theory ignores certain key aspects which are the foundation of the legal system. We shall inspect situations wherein we might find a balance between achieving the core objectives of the law and the application of economic theory. Firstly, we need to understand that although the criticism are accurate and the economic theory does fall short on key aspects, the economic theory works on the justification of probability. It increases the probability of people taking preventive measures through appropriate deterrence factors. Even though there might still be situations where it might fail, it still produces a positive result, making it more appropriate to adopt than to outright reject. It should also be noted that it is not always true that in pursuit of economic efficiency, a sense of justice or fairness is defeated. The law of torts serves a vital role in upholding the principle of corrective justice. The principle dictates that those who commit wrongs should be held accountable for the harm they cause. By imposing liability on defendants, tort law ensures that victims are compensated for their losses and that a sense of justice prevails. For example, a driver who causes an accident due to reckless driving might be held liable for the injuries and property damage suffered by the victim. This outcome upholds corrective justice by ensuring the driver bears financial responsibility for their actions. Herein, we can see that economic theory and the principle of justice go hand in hand rather than oppose each other. Furthermore, as we have already discussed, economic theory might induce an insurance function. This insurance function helps in better risk allocation and supports the principle of fairness in society. For example, mandatory car insurance helps to spread the financial burden of car accidents. While an individual driver might be liable for causing an accident, insurance companies contribute to covering the costs of medical bills and property damage, ensuring victims receive compensation even if the wrongdoer driver lacks the resources to fully cover the losses. We have already discussed one such situation. Wealthy individuals or corporations that argue against economic theory. Another situation might be one of the applications of economic theory in situation of strict liability. For example, pursuing strict liability might deter risky activity and uphold corrective justice, but it can also increase the cost of doing business and potentially harm economic efficiency. Hence, the primary challenge of applying economic theory to legal system, or in our situation to the law of torts, lies in finding the balance between the various goals that might be at odds with each other or may go hand in hand in certain situations. The key to achieving this balance is flexibility. The legal system might be able to offer this flexibility through the discretion of courts, which can analyze unique circumstances and innovate appropriate solutions while promoting safety, fairness, deterrence, and justice, while also taking economic efficiency into account. So, to conclude it all, the economic theory does provide valuable insights and a reasonable perspective on analyzing the impact of law of torts and provides due justification for the remedies. That entails making it a reliable tool for shaping societal behavior. But as we have seen in certain peculiar circumstances, the economic theory might not stand true. This lecture has explained the various aspects associated with economic theory and its interface with the law of torts by analyzing both its positive impact and its critiques. We have acknowledged that human behavior is not always purely rational. Transaction costs can impede efficient bargaining, and a focus solely on efficiency may neglect issues of fairness and deterrence. However, despite its limitations, economic theory remains a valuable lens for understanding tort law. By considering the economic implications alongside other important goals like corrective justice and deterrence, we gain a more comprehensive understanding of the complex objectives that tort law strives to achieve. With this, we come to the end of our today's lecture. Thank you very much.